Today we're going to be talking all about petitioning for your kids, whether they're minors or adults. It occurs to me that I've done videos on petitioning for spouses, petitioning for parents, even petitioning for siblings, but not your kids, and it's an important one. We're going to be discussing what happens when they grow older and age out, how to petition for stepchildren and what qualifies as a stepchildren, and some other related details. If you're new to my channel, I'm Puyan Darian, an immigration lawyer, and I put out a similar video on an immigration topic every week. Here we go. The Immigration and Nationality Act defines a child as someone who's under the age of 21. There is no definition for stepchild. Children include stepchildren. So who is a stepchild? A stepchild is someone whose parents were married before the child reached the age of 18, even if they're currently over the age of 18. What does that mean? Here's an example. Let's say you're a US citizen and you marry your immigrant spouse who has a child. And that child is 17 years old on the date that you marry the child's mother, for example. That child, who's your stepchild, now has a US citizen parent who can file a petition, just like you would for your biological child. Let's say that 17-year-old is now 19 when you finally get around to filing a petition for that child. That is still a child for immigration purposes, and that child still has a US citizen parent, so you're good to go. Now that we got the definition of a stepchild out of the way, let's talk about which categories of children you can file a petition for. If you're a US citizen and you're petitioning for a child who's under the age of 21, that's an immediate relative petition. There is no statutory visa waiting time, no backlogs in that category by law. So if that child is in the US, they can probably apply for adjustment of status if they entered legally and meet all the other requirements. If you're not sure what those requirements are, check out my other videos or schedule a consultation with me and we could figure it out. Now, what happens when that child reaches the age of 21? They are actually no longer considered an immediate relative. That would convert to a different category. That's called a preference category. And a lot of the protections for immediate relatives go out the window. That adult son or daughter can no longer be out of status like they could if they were an immediate relative. There is also a long waiting period for adult sons or daughters who have a parent who petitions for them. And that waiting period gets much longer if that adult son or daughter is married. So there's a distinction between married sons and daughters and unmarried sons and daughters. And there's like an 8-year difference in the waiting period between those two categories. If you're a permanent resident, you can also file petitions for minor children and adult sons or daughters. Both of these categories are considered preference category petitions. The only category that we're going to be discussing today that's an immediate relative petition, which basically means we can file it for them even if they're out of status in the US, they could still get their green card if they meet other requirements. The only category there is US citizen parents filing a petition for a child who's under the age of 21. Every other category, whether they're over the age of 21 or if you're a permanent resident filing a petition for these family members, those are all preference categories. So if they're in a preference category, they cannot be out of status and there are waiting periods. So it'll take much longer versus an immediate relative petition. I've done several videos on the difference between preference category petitions and immediate relative petitions. So if this is all new to you, check out some of those videos. They do explain some of the distinctions and benefits of one category versus another category. If you want to petition for your child and they are out of status and they are in the US, the only one of these categories that might allow you to do that is if you're a US citizen petitioning for a minor son or daughter. again, under the age of 21. And there are still other requirements that need to be met. But the takeaway here is, if you're a permanent resident filing a petition for them, they cannot be out of status in the US. That's gonna create problems down the road. Or if they're adults over the age of 21, they cannot be out of status. Otherwise, they might not benefit initially from this petition if they want to adjust their status in the US. There still might be options available, but they might need to leave the United States to get their green card at a consulate abroad. That's a bit of a complicated topic, so be sure to check out my other videos or schedule a consultation with me so that we can go through all of the options that might be available. Alright guys, I know this was a bit of a complicated topic. If you have specific questions about this specific topic, put them in the comments below. You could always book a consultation directly with me, Puyan Darian, by calling my office, or you can schedule it directly through my website. We'll go through all of your life circumstances and figure out a specific plan that best suits your family. If you're new to my channel, be sure to like and subscribe to my channel so you'll be updated about future videos, and I'll see you guys next week for another video.